As John said, I'm with the law firm of Waldo and Lyle. We're down in Norfolk, Virginia. We do one thing. We represent property owners in eminent domain disputes. I'm here to talk to you a little bit about a constitutional amendment to strengthen property rights in Virginia that will be offered in the coming General Assembly session, and then also about one other bill that an interesting proponent, Ward Armstrong, brought last session and will be bringing again. But if we get the amendment, we won't have to worry about that bill. Quickly, let me just kind of say, why do we need this bill? Why do we need this constitutional amendment in Virginia? We need it desperately in Virginia. One, we need to take up Justice Stevens' invitation in Kelo to strengthen property rights at the state level, which our Supreme Court of the United States refused to do at the federal level. A lot of people don't realize, I think, just how severe the situation is in Virginia. We had some legislative assistance in 2007 that was a direct response to that Kelo decision. And everyone, I'm sure, will remember that that Kelo decision is where our United States Supreme Court said that any private property can be taken and handed over to another private entity simply because they're a preferred user by the government. Now, I think all of us in this room understand exactly what's wrong with that, but unfortunately, we only had 4 folks on that court that could figure that out. In Virginia, in 2007, the General Assembly definitely strengthened our situation here, did eliminate those quote-unquote Kelo-type takings. They could no longer take for economic development, which was the rationale that was laid out in the Kelo decision and what that essentially focused on. Also, our 2007 reforms clamped down on the housing authorities, which are some of our biggest offenders in this regard. It's kind of a hand-in-glove situation. They advocate for an economic development program by identifying an area that they want to improve. And how do they do that? Well, they say it's blighted. And who gets to decide if it's blighted? They do. So what you have, of course, is a situation where the one who can exercise the eminent domain power to take blighted properties, and prior to 2007, your property didn't have to be blighted. But if I, the housing authority, drew a circle and only these few properties inside of it were blighted, I could take the entire circle because now I've declared it all blighted. In 2007, the General Assembly put a stop to that as well. But what have we seen since 2007? Every session, the housing authorities, the local municipalities, and everybody else with the power of condemnation has come to chip away and chip away and chip away at what was done in 2007. And so while we do have a slight bit of protection right now, it's only as good as our next General Assembly. When they decide, the hell with that, we're done, we got to give these guys their power back and let them keep on with this economic development because, of course, they know best how to reform and build our cities. So what this amendment focuses on is ending for good in Virginia the economic development rationale that our housing authorities and other folks around the state are using to take private property and hand it over. Many of you may have heard about a case, got some publicity around the state and actually nationally, down in Roanoke. It was exactly this scenario. We called it Virginia's Kelo. Our clients that I was privileged to work for down there had exactly that situation occur. Carillion Health Systems, largest employer in the Roanoke Valley, decided we want this 110 acres. We're going to build, our kingdom down there, basically. And so they went to the Roanoke Housing Authority and said, we want that 110 acres. They worked out a deal starting in 2000. Documents all over the place to show exactly what they were doing. Fast forward, our client's property was taken on June 29th, 2007. 48 hours before the 2007 legislation would have protected them and they couldn't have touched it. We need this amendment to make sure that situations like that never occur in Virginia again. So let me hit some of the highlights. The language is being tweaked. We're very close to having language that we believe will satisfy certainly the strict nature that we need to have. This is a constitutional amendment. This is no place to be screwing around with compromise, and so we're helping to put together the strongest language that we can provide for Virginians. And so, what is some of that language going to be? It's going to state flat out that private property ownership is a fundamental right. It will say that the property can only be taken or damaged for the public's use. This is often a point of confusion. Our Constitution in Virginia says that the General Assembly gets to define public use, and they can only take property for public use. That, through a number of different federal and state court decisions, has gotten twisted into public purpose, which is a much broader expanse of things that can be done with the eminent domain power. We'd like to see the language specifically say public's use, which means use by the public, which is what our founders meant when they said public use. We think that's very important. It of course will eliminate the economic development rationale so that private property can't be taken for private benefit, gain, or profit. And it will include language to deal with the blight condition so that property must actually be blighted to be taken. And one of the more important things that we think has got to be a part of this amendment is presently you, the landowner, bears the burden of showing that whatever use is being announced for your property, you bear the burden to prove, or I'm sorry, to disprove that the use is public, that it's a public use. We think that's totally incorrect. I think the burden ought to be on the government to prove to us this is a public use. So this burden shifting is another component of what should be involved in this amendment. And that's kind of on the public use side of things. Of course, our Constitution demands that just compensation be paid when property is taken by the government for a public use. And so we see some problems presently with Virginia law because just compensation is not paid. Our courts have defined just compensation to be a full and equal equivalent for what is taken from you. In Virginia, no one is paid justly. You're not compensated or reimbursed for your attorney's fees. You're not protected from business losses. You're not protected from a number of things that occur to you when your property, your business, your home, your farm is taken, and you are left in a condition that your property has been stripped from you, but then you've been involuntarily hauled into court and you've incurred attorney's fees, experts to fight over exactly what's going on your property. We think that's wrong. I think that Virginia needs to follow the lead of a number of other states who make sure that their citizens are fully protected and that just compensation actually means justice in compensation. And so there are some components to this amendment that we believe will strengthen Virginians' rights to be fully compensated. And so, you know, the way I see it, this seems pretty common sense. You know, I don't see the problem with it. Not everybody sees things our way. So what are our opponents going to be saying? Well, in 2007, Dick Saslaw stood up on the floor of the Senate and when a similar amendment was offered, said the protection of property rights does not belong in the Virginia Constitution. Does not belong in the Virginia Constitution.
Fiery.
So this is the mindset that we have to focus on. These are the folks, and the House, I think we're going to be fine. You know, it'll come through the House. The Senate is where we're going to need everybody's help and in being in touch with your senators, mobilizing folks to be in touch with the senators, and coming down to Richmond to stand up and say, do the right thing here. Protect property rights. It's the most fundamental right that we have. Without it, what else can you do? You can't worship freely. You can't speak freely. You know, I love to go through the Bill of Rights and say, well, why do you have a gun, right? Why do we have the Second Amendment? So you can defend your property. it all comes back, I think, very easily to this fundamental right of private property, and we hope that in the coming session we'll find the votes to recognize exactly what needs to happen to strengthen our protections of private property in Virginia. The process for amending the Constitution in Virginia is lengthy and cumbersome. It will require that this amendment be passed in the 2010 General Assembly. We have the intervening election at the end of 2010, and then the exact language has to be passed again by the 2011 General Assembly before it goes to the ballot in 2011. So it's a long process. We're at the front side of it, but the timing is right. The intervening election, and I think the general tenor in our country, and certainly in Virginia, lends itself to the momentum and the support, I think, that will push these guys to do the right thing here, hopefully out of self-interest, if nothing else. But it is a long process, and there'll be a lot in the years to come. Let me mention one other bill that'll be coming up as well. Ward Armstrong brought a bill last session, and usually I see what he's bringing and I shriek in horror, but he brought a great bill that deals with loss of access when property is taken. And what we have in a lot of instances is not an entire property is taken, especially in like a VDOT taking where they're widening a road. They might just be taking 15 feet, 25, 30 feet off the front of your property. Often they will shut some of your access. So let's say you've got 2 driveways and they'll come through and they'll close one. Okay. Presently, it's not automatic that you're entitled to be compensated for that loss of access. Presently, it's a jury question whether you're left with a reasonable access. I don't think that's correct. I think if you're losing something, you ought to be paid for it. So Ward Armstrong brought a great bill to say, if you lose access, you ought to be paid for it. Went through the House just fine, thanks in part to the Speaker, and died very, very quickly over in the Senate. One of the things that was used to kill it, especially over on the Senate side, was the attachment of a fiscal impact statement. And they did this at VDOT's request, really at the 11th hour, to slow it down and get it kicked over to appropriations out of courts of justice and then back over where it died. From what I understand, there were more of these fiscal impact statements attached last year than certainly in recent history. It's a tool that's used to slow things down. And in some instances, I think that's maybe not a bad thing. But when we're dealing with a fundamental right of private property ownership and the government's obligation to pay you just compensation under the Constitution, the budget, frankly, doesn't matter. I don't think we put price tags on fundamental freedoms from any other rights, and we ought not be doing it for private property ownership.